and record. All right. So this session is currently being recorded, and a link will be available for viewing on gsacnaples.org. This will be emailed through our database by the end of the week. If you'd prefer not to appear in the recording, you may simply turn off your camera by clicking on the camera icon in the lower left-hand corner of your screen. Let's see, to receive updates on future events like this, please make sure to visit gsacnaples.org and register for email updates on the pop-up window of our homepage. As our panelists do speak, I will pin them to the main screen so that you can hear directly from the speaker. So please make sure you're in the speaker view of your Zoom meeting, and that is in the upper right-hand corner of your Zoom settings. When you enter the room, you're automatically muted. As a courtesy to other attendees, please leave yourself muted for the duration of the meeting. If by some chance you do lose connection, you can click on the link or enter the meeting ID. You will again be placed into a waiting room, but we will be monitoring that, and we will make sure that you get back into the room. If you have questions during the meeting, please make sure to submit them via the chat box. I think we already covered that. And then, of course, at the end of the presentation, we'll make sure to share the contact information for today's panelists if you'd like to reach out to them for further information. And I do want to touch base that we do have a disclaimer. This forum is for informational purposes only. There are experts that are available to guide you, and please take the responsibility to confer with your legal advisors. With that, I will turn the meeting over to David Feight. David, can you unmute yourself?
I am, I believe. Yep, I'm unmuted. You can hear me?
Yes,
okay, good.
you.
Good. Good morning, everyone. Thank you for being here this morning. And I want to say on behalf of the entire GSAC board, I'd like to welcome you to today's forum. And again, thank you for attending. And my apologies for us getting off to a little bit of a slow start. I know Cindy had mentioned that we had kind of a record attendance signing in this morning. We're trying to upgrade our number of people that can participate, but we've had well over 100 people trying to be on the Zoom, which is very rewarding from our standpoint. So as you know, our membership encompasses virtually all of the condo associations on Gulf Shore Boulevard North from Admiralty Point through Naples Cay, which totals over 4,400 individual condominiums. Your GSAC board is committed to serving the boards and the residents of our members through communication, education, beautification, and civic advocacy. As you know, the recent legislation that resulted from the tragic events at Surfside is complicated and will most likely have significant impacts on all of us. Therefore, as part of our education mission, we thought it was important to put together today's forum. Board members Daryl Shaw, Howard Handler, and Jeanne Seewald have assembled an outstanding and well-respected panel to discuss the implications as they see them. I know you will gain a lot from the next 2 hours. I know I did in preparing for today. So let's get started. I'd like to ask Jeanne Seewald to introduce our first speaker. Jeanne?
Thank you, Dave. Good morning, everybody. I'm Jeanne Seewald, a business and intellectual property attorney here in Naples. I've been on the GSAC board for about 3 years, and I live at La Ciel Venetian Tower. It's my pleasure today to introduce our first speaker, attorney Steve Falk. Steve focuses his practice on legal issues relating to condominiums, community associations, and country clubs. He's Florida Bar board certified in condominiums and plan development. Steve is a true expert in the area of condominium law. We're very pleased that he could be with us on the panel this morning. So Steve, take it away.
Thank you, Jeannie. You've put a lot of pressure on me. So I guess I'll have to sound like an expert, even if I may not be one. So. But thank you, folks. I appreciate you participating in this seminar, and I also want to thank the board at GSAC for inviting me to be a speaker. So, as Dave said, we had a tragedy over on the East Coast last year, And in reaction to the collapse of the building, the Florida legislature approved Senate Bill 4D, and it became effective when the governor signed it into law in May. Normally, legislation has a delayed effective date. Normally, legislation becomes effective July 1st, but it became law once the governor signed it. And we can debate the desirability of some portions of this law. There was a lot of political pressure on the legislature and the governor to enact this legislation. I can only speak for myself. We obviously want buildings to be safe. We want people to be safe in their condominiums. But this legislation really is a good example of a one-size-fits-all legislation. This has imposed obligations on condominium and cooperatives for buildings that are 3 stories or higher. This does not apply to homeowners associations or I think there was one email question about how does it apply to an HOA, and the answer to that is it doesn't. Issues that may be confronting older buildings, and in Florida, that would be, let's say, 50+ years old, although there's condominiums on the East Coast that were built in the 50s and 60s, many more than over here in Naples. So for GSAC, there are some buildings that by Naples standards are older buildings that maybe have 3 stories or more, that were constructed with different engineering design and construction techniques than the high rises directly on the beach. But again, this is a one-size-fits-all legislation that is really going to create major issues for buildings, condos and co-ops that manage buildings that are 3 stories or more in height. There are 2 main topics that I'll talk about today. One are milestone inspections, and the other is structural integrity reserve studies. Cindy, do you have the outline up on the screen for people to follow along with? Okay, well, I'll proceed.
I have the article that was emailed ahead of time, or
You do have the article up. Okay.
I'll pull the article up right now. Absolutely.
Okay, thank you. Thank you. So I will start. The first item is the milestone inspections, and this is an amendment to section 553.899. And I don't have it memorized, so I'll quote from it. A milestone inspection is a structural inspection of a building, including an inspection of load-bearing walls and the primary structural members and any primary structural systems by a licensed architect or engineer authorized to practice in Florida. So it has to be done by a licensed architect or engineer who is Florida licensed, that attests to the life safety and adequacy of the structural components of the building, and to the extent reasonably possible, determining the general structural condition of the building as affects safety, including necessary maintenance repair. Now, the purpose is not to determine compliance with the Florida Building Code or the Fire Safety Code, but the purpose is what it says in the definition of the statute, This has to, again, as I said, this applies to condo associations for each building that is 3 or more stories in height. Now, you will see in the paragraph below the definition of milestone inspection, you'll see a reference to the deadline in the statute, but that doesn't apply to GSAC members because there's a special, there's an exception to that general rule that if a building is located within 3 miles of the coastline, each building that is 3 stories or more in height must be inspected by December 31st of the year that is 25 years from the issuance of the certificate of occupancy for the building, and it must be conducted within 10 years after. Okay, so it's 25 years after CO, which is just short for certificate of occupancy. The statute does say if the CO was issued on or before July 1st, 1992, The deadline for the milestone inspection to be performed is December 31st, 2024 rather, December 31st, 2024. There is a glitch, there's an omission from the statute. For example, assume that the certificate of occupancy was issued in 1994. 25 years after that is in 2019, which is 3 years before the statute became effective. So that is an omission in the statute. The only way that I can make sense of the legislation with respect to a building, for example, that was where the CO was issued after July 1st, 1992, is that the deadline is December 31st, 2024. Now, notwithstanding these deadlines, if the city of Naples determines that this is required for particular buildings within its jurisdiction and sends a written notice to the association by certified mail, the deadline is 180 days after the association receives that certified notice. And Cindy, if you could scroll down to the next page, I'd appreciate that. Okay, so December 31st, 2024, but it could be as early as 180 days. Now, I have discussed this with the rest of the speakers. I've asked my clients, have any of you received a notice from the city of Naples? And the answer has been no. This legislation is extremely problematical, as we'll go into more detail. I am hopeful that the city of Naples will not issue that, will issue that notice later than sooner because of all the complications in the statute. This milestone inspection has to become an official record of the association and maintained for 15 years. Owners, tenants, prospective purchasers have a right to inspect and obtain a copy. An officer and director who willfully and knowingly fails to have the milestone inspection performed is guilty of a breach of his or her fiduciary duties. Now, the first portion of this milestone inspection is a visual examination by a Florida licensed architect or engineer. Okay. That person has to inspect the building and make a determination as to whether there's any visual evidence of significant structural deterioration, not cosmetic problems, not hairline cracks, major substantial structural deterioration. And I'll quote from the statute, it means substantial structural distress that negatively affects a building's general structural condition and integrity. We're talking about major structural problems. If there is no evidence of that visually, then the architect or engineer issues his milestone inspection report, sends it to the association, sends it to the city of Naples, and then you're done with that portion of the legislation. If a secondary inspection is required, then the engineer architect does a very intensive investigation of the building, which can include destructive testing. The next part of my presentation deals with structural integrity reserve studies and reserve funding. As you'll see in the materials, the structural integrity reserve study is defined as a study of the reserve funds required for future major repairs and replacements based upon an visual inspection by a Florida licensed architect or engineer. The statute, unfortunately, uses the term common areas. That is another glitch because a condominium and a cooperative don't have common areas. They have common elements or they have cooperative property, but I think we can reasonably conclude that the reference has to be to, that's just the glitch in the statute. Now, a licensed Florida architect or engineer has to perform the visual portion of the milestone of the structural integrity reserve study, but anyone else who's competent to do a reserve study can provide the rest of that. So it would be the dollar amounts, for example, and I'll let the other speakers go into more detail. Now, currently, reserves that have to be part of a reserve study, which is not necessarily, which is not an in-depth audit of a building from a structural standpoint. Those required reserves before the statute became effective were roof reserves, painting and paving, and any item for which the deferred maintenance cost or replacement cost exceeds $10,000. So when we're talking about reserves under the Florida Condominium and Florida Cooperative Acts, and any normal definition of reserves, we're talking about discrete components of a building for which the estimated life expectancy is less than the entire building. Okay, so for example, the roof will wear out before the entire building wears out or has to be replaced, if at all. Same thing for paint, same thing for paving. In a high rise, a cooling tower, elevators, pool. That is the normal definition of reserves. Well, the Florida legislature in this legislation has expanded that substantially. For example, you'll see in the outline, you'll see reference to the roof, load-bearing walls or other primary structural members, floor, foundation. Now, when would you have to replace a load-bearing wall? When would you have to replace a floor or the foundation or load-bearing walls or floors throughout the building? How can an architect or engineer determine the life expectancy of items like that? Why would you fund a reserve for items where the likely life expectancy is equal to the entire building? And for example, how would you even begin to replace a foundation, for example, on a 20-story building? So my role is just to pose these difficult questions, and I'm gonna stick the rest of the speakers with the difficult task of answering those questions, which I'm not sure that there is an answer to them. Other reserves, fireproofing and fire protection systems, that would be fine. Plumbing and electrical systems. Now, B through D are really the most problematic of the statute, but plumbing and electrical systems. I don't have clients who have reserves set aside for plumbing and electrical systems throughout the building. Why would you have to replace all the plumbing and all the electrical systems? You might be required perhaps at some point to upgrade the electrical system. Would you have to rewire the entire building? Some older buildings have plumbing where over time the cast iron pipes degrade and they may have to replace all of the cast iron. Some of my clients in the older buildings have done that over time. Would that ever be the case in a 20-story building with construction methods built from, let's say, the mid-80s forward in Park Shore Beach? Well, that's an issue. Waterproofing exterior painting, that was already in the statute. Waterproofing arguably because it's part of painting. Windows. What if the condo or cooperative governing documents obligate owners to replace windows, not the association? Why would the association collect a reserve for an item for which it is not obligated for the maintenance, repair, or replacement? Again, these are questions I pose. I'm not sure what the answer to those are. I don't have a good answer to those questions. Now, before we get into more detail in the statute, and this is where my clients have asked me, well, this is all very interesting, Steve. What do we do about this? What about this deadline? Should we get going on this? Should we hire an architect, an engineer to do these inspections, et cetera? And it's a difficult question to answer, but there will be efforts in the 2023 legislative session to change this law. I know that the Florida Bar and other interest groups in Florida will be addressing that with the legislature. There are people working on this right now in a legislative capacity. I think the chances of a change to the structural integrity reserve study portion of the new legislation is more likely than with respect to the milestone inspections. Okay, and for structural integrity reserve studies, I think the focus, one of the focuses will be on items B through D and F, G, and I, the ones that I just discussed that are problematic. The other reserve that must be in the reserve study is any other item that has a deferred maintenance or replacement cost in excess of $10,000, and the failure to maintain or replace impacts on the structural integrity of the building. Now, associations existing on or before July 1st, 2022, which are controlled by owners other than developer, that would be all the buildings in GSAC, must have a structural integrity reserve study completed by December 31st, 2024. Again, this is for each building that is 3 stories or higher. I should have mentioned earlier in my presentation that the statute does not define how you determine 3 stories or higher. There's no definition in the statute, and there may be cases where there's a question as to whether a building is 3 or more stories higher. Now, for you 20-story buildings out there, there's no ambiguity there, but for some buildings, the question will be, how do you measure that height? Now, a structural integrity reserve study has to be completed every 10 years. The next portion is extremely problematic. As of December 31st, 2024, an association may not waive or partially fund reserves for building components required in a structural integrity reserve study. Before this legislation was enacted, owners in a condo or cooperative could waive reserves, statutory reserves, or partially fund them by a vote of majority of the owners in the building, assuming a quorum was established. When I say a majority, that assumes that each unit has 1 vote. Okay, it's a majority of the voting interest, which is the total number of votes that can be cast. So more yes votes than no votes, assuming a quorum was established at the members' meeting. With respect to these items in the list that I just discussed, as of December 31st, 2024, the members cannot waive or partially fund reserves. They cannot be used for other purposes. So all of my clients that are on Park Shore Beach, Pelican Bay, Vanderbilt Beach, I would say almost all of them, probably 95%, fund reserves based upon the pooling method by which the reserves can be lumped together. Any reserve funds that are allocated for 1 building component can be used for any or all of the components in the reserves. Okay, as of December 31st, 2024, that cannot be done. So the question is, can you do pooling? You might be able to do pooling based upon all of those structural reserves as opposed to the rest of them. But I think in all likelihood, the Division of Florida Condominiums would say, no, you can't use the reserves for the foundation for, let's say, painting, which is obviously more likely to say that it's an understatement to say that's more likely to be used. There's more we can get into, but I think that concludes my introductory remarks. And I think there will be the question and answer will be later in the program.
Absolutely. Thank you so much, Steve. And let me bring Daryl up here to introduce our next speaker.
Okay. Thank you, Cindy, and good morning, everybody. I'm happy to introduce Richard Algoo of TRC Worldwide Engineering. Richard is an engineer and senior project manager specializing in structural engineering and building envelope services. He has experience on projects big and small, from single balcony restoration to hurricane strengthening of high-rise structure envelopes. And he has worked on projects for municipal, commercial, and private entities. Richard, it's a pleasure to have you on our panel. I can tell everyone from my firsthand experience that he is responsive and a great team player. He interacts well with clients and architects, contractors, design teams, and other support personnel. And he's been a great help to us here at Harbor Cove on the many projects we've worked on in the past. So Richard, I thank you again for participating. Could you talk to us about the requirements of the new law and as it relates to building inspections, and also tell us about timeframes for compliance?
Yes. Thank you, Daryl. Thank you so much, GSAC, for inviting me in to participate in this legislative SB4-D reserve commentary. As noted, I'm sure everybody's seen all the correspondence coming through the pipeline regarding SB4 requirements starting since late May of this year, 2022. Of main importance, basically, this law is essentially to create a system of belts and suspenders. On the East Coast in particular, they had what was called the 40-year recertification review. And this was relative to Miami-Dade County. And that consisted of a visual structural review of an existing structure, 40 years or older, which also included an electrical review of the building as well. And then providing necessary documents that Miami-Dade actually drafted and put together on their website that an engineer or a registered architect in the state of Florida would complete and turn in, which would in turn be submitted to the building department or AHJ authority having jurisdiction over that specific area that the building is located in. This new law, SB4-D, basically is an expansive or evolution of that 40-year recertification that started in Miami-Dade County in about the early 90s. This new law requires that a Florida registered engineer or Florida registered architect perform a milestone inspection review, which, as Steve mentioned earlier, there's a phase 1 inspection that is based on visual review of the building. This includes structural elements of the building that is relative to Florida Statute 627.706, where they define these are the elements that you should be looking at. Essentially, what these elements are primary structural framing elements. These are critical elements of support for your building framing system, and what they call basically a collaboration of where these elements come together. So they break it down in 2 different sections. The new law also specifies a phase 2 inspection. So a phase 1 inspection would be registered Florida engineer or architect performs a site visit out at the site. They look at those elements specified on the Florida statute 627.706, and they're going to make commentary on them. They're looking for any signs of deterioration, anything that could become an issue with structural for the building. Now, if we, as the engineer or the licensed architect, sees something that tips them off saying, hey, we see an area for a potential problem in the future, we recommend follow-up. Now, this follow-up could be a secondary review, and it could include, as Steve mentioned, destructive testing at certain locations. As we all know, there's a lot of elements of a building that are just not visual, not able to get access to. Pool shells are very critical about this, where you have plaza decks and you have a garage space underneath for underground parking. You're just not able to look at the structural elements of those areas because they're simply covered up. So this new law, SB4-D, has some provisions for that, saying, okay, we know that you cannot access certain areas to perform a substantial visual review. So as such, if you see any items that you believe could require additional review, this is where that phase 2 inspection would have you covered. It would also cover the building as well. We understand this would take a little bit more time. That's why under the requirements of the new law, where they're saying, we want to have this document turned into us no later than December of 2024 for compliance with the new law. So as such, okay, this phase 2 is going to buy you a little bit more time if we find that there's areas that need additional review. Also, regarding that phase 1 inspection, this new law is saying, hey, engineer or architect performing this review, there should be something called a SEERS performed, which is Structural Integrity Reserve Study, where Steve mentioned again, there's about 6 or 7 items in that list where they want, basically the engineer should be assisting, the engineer architect should assist with, okay, these are items that should be funded by the association The engineer should use their experience to help determine, what kind of money should be put into these funds. They did leave these items very vague. It says roof on one, doesn't have any delineation for floor, because floor as an engineer can mean several different things. Could be the flooring material, flooring on top of structural floor, or framing of structural floor. So, where's the breakdown for that is what I've been stepping back to as I review this SB4 law and requirements for it, for what they're going to request in terms of that report for the milestone inspection under phase 1, because they're going to be looking for that in particular. Other items of concern that I've seen in there, again, like Steve noted, there's comments about windows, comments about plumbing and electrical systems. Again, a structural engineer or an architect would not be reviewing those areas. So, how are we to assist in the Sears structural integrity reserve study with trying to help the reserve specialist put together what kind of numbers should be put into that thing to help fund this thing in the future? Again, a foundation, there is no requirement in the building code saying this is what the service life should be. This is when there should be some kind of maintenance done on that, because again, these are items that you can't see. It's not an item that's easily accessible in any means underneath the building, because this is the component that supports the structure. Again, in there's I want to mention there are some loose terms that don't make sense. Like, okay, what is substantial structure deterioration? What is the definition of collapse or imminent collapse? Because those are items that are listed in the code, but there's no specific definition for them. Again, that pushes back on the engineer for what they determine to define those elements by. Me personally, I look for basically as an engineer, I look for my professional canons. What am I supposed to be performing as an engineer? What is my duty as an engineer? And the number one canon as an engineer is to ensure the health and safety and welfare of the public. That determines basically, okay, I need to be looking out, number one, safety of people in the building. So we all know buildings of this age, buildings in our location where we have full exposure to the environment, where most of our buildings are located on the water. They see full exposure from the environment, being sun, chlorides in the air, significant rainfall, storms and such, and that wears and tears on buildings. In particular, on concrete buildings, back in the 1980s or so, there were no requirements for waterproofing of concrete structures. So when they built a lot of these buildings, that concrete was exposed for years before any kind of maintenance was done on it, even before the paint was put on the building. This dates back to materials used during construction. How good was the structural steel used that was embedded in that concrete to form reinforced concrete structure, to perform composite action? How long was that steel sitting outside? How much corrosion was already on that bar before it already got put in the form and then cast with concrete? How good was that concrete mix back in the 1980s? What kind of additives did they use to try to protect anything that was embedded in that concrete? These are all items as an engineer that, things I'm thinking about as I'm reviewing this law. All items that I know, okay, buildings see certain wear and tear. This is things that are normally going to happen. And this is where we account on buildings keeping up with your maintenance cycle. That's your most critical item that's going to, dictate how much restoration you're going to have on your structure, honestly. Because if you keep up with your cycles, which is about, in my experience, every 10 to 15 years, you're going to have some kind of project on the building where you're maintaining structural framing element. Structural framing element is what I define as your floor slabs on your building, your concrete slabs, concrete tie beams for support of the building that ties everything together, concrete columns that supports the main structure, concrete beams or steel beams in some items of that, because the main items we have down here are structural steel framing and structural concrete reinforced. I've touched on the structural concrete items being that, spalling and delamination of concrete is very typical. As mentioned, noted, based on our exposure here, we get items like that. Now, this law does say, okay, there is some deference to some of the spalling. Some of it is not as critical as other items. And this is what the engineer should determine based off of their experience. Now, like I mentioned prior, because I'm an engineer and I follow that, I have to maintain the life safety of the public. There's specific items that this new law and the code does not define clearly, saying yes, certain cracks are acceptable, certain spalling is acceptable, but the engineer should say what should be of concern, what should be addressed now, and what should be deferred in the future. Now, like I mentioned prior, we're going to have spalling in some locations. Now, up to the engineer should say, okay, what spalling is critical? Now, to me, okay, so let's say an example, I have a cantilever slab that hangs off the side of a building. If there's cracks at that slab up against the wall, that to me is immediate concern. And that's something that I would flag and say, this requires phase 2 inspection, and it should be addressed, almost immediately, because that would lead to substantial collapse, in my opinion, based off of what I'm reading in this code here. So, I'm going back to there. I'm reviewing this law, and again, there's just some items that to me are just not 100% clear. And based on that, I get that they gave us a timeline of, okay, 2024, we need to get these reports out to the building department. Now, again, we all know these days there's a lot of problem with manpower. So they tried to make this law a little bit clearer, saying, okay, engineer, we know you're going to issue a report. And also on top of your report, we want you to give us a 1-page summary of that report saying, okay, if you identified any critical areas, I want that listed first to me, so that when we receive it at the building department, we can find that immediately and we can put that in our files. Now, again, there's going to be multiple hands that are required now. The engineer is going to turn in the report to the building department. The building department's going to have some kind of separate entity working for the building department to compile all this information. At the same time, the building department's going to have to take all these included documents that were supported. They're going to have to put them together, and they're going to have to determine, now, what is our course of action? How do we go back to this building and say, you have X amount of time to perform this work? Or there could be a problem with collapse or some kind of issue that the engineer identified in their report under phase 1 or phase 2 of their review. Again, the Florida Building Commission is the one who writes the building code that the engineers follow in the state of Florida. So once this legislation actually went out and was released in late May of this year, the Florida Building Commission has actually started putting together some commentary on this. And as of July 14th, I've received some of that commentary for review. There are a lot of positive things in there to try to define those undefined areas that I mentioned prior to making sure that the engineer is following what's required for this new law. However, they have until the end of this year, that is December of 2022, to put in their final commentary. So what I'm seeing is the way that this is evolving is I would not reach out to any engineers right now or licensed architects to say, please give me a proposal to meet the requirements of the SB4 law, which is the milestone inspection phase 1, or if required phase 2, or that reserve study, structural integrity reserve study. I would reach out to engineers starting early January of 2023. And what I would request from the engineers or architects is say, I would like to get added to your list for performing this review study in accordance with the SB4 law, because the engineer and architect does not 100% have defined what is going to be required in those milestone reports. As a result, waiting for that time when we see the evolution of this law and the final documents put out to say, this is what's going to be required of you as an association. This is going to be required of the engineer or architect performing this review that's required to be submitted to the building department. That would be the best time to get an actual proposal from an engineer to define each area and make sure that every item that's listed is going to be covered by these reports. It's going to save you a lot of time and trouble with additional reviews and follow-ups as well. Beyond that, let's see. Again, we know that associations are now required to fund these reviews as well. So this law does state in there that, okay, it is up to the association to pay for these third-party engineer or architect reviews. So that's something that was #1 listed in this law and had to be covered. Again, this is a glitch bill as noted prior. So this is ever evolving, and every few weeks or so, I get emails on this from lawyers, engineers, architects, all adding input to this legislation, calling for, okay, this is things that are unclear to us. We ask for clarification on this. We propose additional changes to this law. We would like this or that addressed in this item. Again, as an engineer, there's some fallacies I see personally in this, being that they call it structural review or structural integrity, but it doesn't ask the engineer to even look at plans for the building. It's saying, here, do a visual inspection on it. But again, there's some information that I'd recommend that whoever you choose to do this work should be doing in the background. Again, those are the items I wanted to touch on. And Daryl, please take it back. I appreciate it.
Okay. Thank you very much, Richard. That is some great information and we really appreciate it.
Thank you.
So moving on now to our favorite topic, money. I'd like to introduce Will Simons from Association Reserves. Will has extensive experience in the condo and HOA reserve industry and has completed or overseen more than 1,800 reserve studies, as well as spending time in the insurance and commercial real estate fields. Will has been a presenter at numerous educational seminars and has served as the treasurer and vice president of his own HOA, representing a community of over 600 homes. So Will has seen it from both sides of the fence and can relate to our issues. Will, I want to thank you for being on our panel. Could you tell us about the value of reserve studies and how our associations will be impacted by the new legislation?
Yeah, good morning. Good morning, everybody. Thanks for taking some time out of your day to join us. And I want to commend our first two speakers, Steve and Richard. I think you guys did a great job breaking down some of the technical aspects to this legislation. And there's certainly a lot to talk about here. To pick up on your question there, Daryl, yeah, for those that are unfamiliar with a reserve study, notice I'm saying reserve study, not structural integrity reserve study, but traditionally a reserve study, as it's been known for the last 40 years or so, is a financial planning document. The reason why you do a reserve study is to forecast and budget for major projects. It is a financial instrument, basically. It incorporates elements of building science, right? Understanding what causes things to fail, what life expectancies are for various components, understanding what it costs to replace these things. Those are kind of the nuts and bolts of a reserve study that we then use to put together a timeline of future expenses. But the big picture here is for associations to reduce the risks of financial distress, specifically special assessments, loans, emergency lines of credit. Those are all what happen when you don't have reserves. Last week, I gave a couple of talks and I kind of hit on this little light bulb moment where I said, 99% of the time, there's nothing special about a special assessment. It is just the inevitable result of not having reserved for something that you should have. So that's what we do. Our company's been in business since the mid 80s. As a company, we've done over 70,000 reserve studies. We have been early proponents and kind of pioneers in the industry, helping to develop what are called National Reserve Study Standards, which have been endorsed by CAI, the Community Associations Institute, for more than 20 years now. The reason I'm saying this is to establish that reserve studies are a known concept. This is an industry that's been around a long time. There's a lot of very qualified professionals out there with industry standards, with qualifications that kind of govern what we do. There's standardization about what goes into a reserve study, the types of things that you need to fund for, and so on and so forth. So I bring that up because, as you see there on the slide, this new idea of a structural integrity reserve study, to me, is kind of a Frankenstein combination of two different services, which are very different. You have structural inspections and evaluations. Sometimes they're called property condition assessments, whatever the term you want to use. That is when you bring in a company like Richards and they do their thing. They go into detail. They do a detailed overview and inspection of a property to identify and diagnose what's wrong with it and recommend some fixes and help oversee that project. What we do in a reserve study, again, is a long-term financial planning document. Yes, sometimes there are immediate things that need to be done in a property, and we will certainly highlight those. But really, it's something that is used for the long term. It's looking out 10, 20, 30 years and forecasting not only what needs to be done now, but will need to be done in the future and what that community needs to do about that. So just to take a step back and kind of zoom out for a moment, I think, if we look at what happened last June, and the challenge that posed for our politicians. That's, I think, for a lot of these folks, maybe the most difficult thing they will ever undertake in public service. So, you know, I give them credit for having their hearts in the right place. I think the spirit of this legislation is good. They're trying to protect and serve the public. You know, I think just from a big picture standpoint, that's good. The execution of this legislation is where there's room for improvement. And I think we all agree that, you know, you've heard from 2 other speakers. I'm going to try not to repeat myself or, you know, repeat what they've said too much, but I think they nailed it. You know, there's a lot of things in here that are confusing that, like I say, they're maybe redundant. You know, this, I guess I'll just speak from the perspective of a reserve study provider talking about this structural integrity study. To me, it's kind of redundant with a milestone inspection, at least in the sense of having a professional look at your building for things that need to be fixed. You know, there's a lot of carryover between one and the other. To me, the law is not really clear about whether one inspection can satisfy both requirements, or if there's some period of time where you would have to do one close enough to the other. You know, if you've just had a building inspected for a 40-year certification, for example, last year, could you use that same information to qualify as your milestone inspection and your SEERS? I'm just going to call it SEERS. You know, there's a lot of things that are not, to me, made clear there. Another problem, you know, we talk about the frequency of how often these need to be done. You know, it's been the best practice in our industry for a long time that reserve studies need to be done ideally like every 3 years, if not more frequently than that. So if they're going to bother to put a reserve study requirement in the law, I would say let's at least be consistent with existing best practices. You know, there's many states now in the US. We operate in all 50 states, so I can tell you with authority here, there's existing law in places like California and Virginia and Nevada, and you know, more and more states, it seems like every couple of years, are adding reserve study requirements, and it's typically every 3 years that you have to have a fresh on-site inspection done. The reason for that is that things change. I mean, the data that goes into a reserve study, namely the life expectancies and the cost points for all these components, those are things that will change on a pretty dramatic basis. Obviously, within the last 2 years, we've seen that. You know, if you had a reserve study done in 2019 or 2020, almost every cost estimate that was in that study, unfortunately, is not going to be accurate anymore because of the inflation that we've had. So doing them more frequently is a good thing. That gives communities a chance to course correct more frequently. They won't drift off course financially if they're only doing this every, or I should say they will drift off course if they're doing this only once every 10 years. That's not frequent enough to keep pace with the change of the market. I think that a lot has already been said about the scope of work, you know, what's required here. I'll just echo what Richard said, that, you know, you just can't visually inspect a lot of the things that are in this bill. Curiously, they left a bunch of things off the list that I think were automatic, you know, no-brainers that they should have. They didn't put elevators on there, for example. I mean, every single building that's represented on this call, I'm sure, has elevators, which cost hundreds of thousands of dollars each if you're in a high-rise building. So I don't know why they didn't put that on the list. Major air conditioning systems, you know, cooling towers, package units for hallways, generators, you know, there's a lot that could have been on the list that wasn't. I'll echo what was said earlier about plumbing and electrical. Those are very broad, vague terms that should have been made more clear. So yeah, I mean, the scope of what is supposed to be done here doesn't make a whole lot of sense. There are things that got left off the list that should have been there. We'll see what they do with that. I mean, we're certainly making our voices heard as much as we can. I'm in a, you know, kind of a discussion group with a bunch of other reserve study providers in Florida, working on effectively a joint response on behalf of the whole industry to say to our legislators that, look, you guys got a few things right here, but you know, don't take it from any one of us, take it from all of us. Here are the things that you really can't do. That you're just going to shoot yourselves in the foot with your intentions here, which again are to make sure buildings are inspected more frequently and that they are funding and taking care of their properties. I mean, that's, you know, something that's been overlooked in Florida for far too long. So The volume of work is another one we can talk about. There are, I don't know how, the numbers are a little bit fuzzy, but I want to say there's something like between 25 and 30,000 condo associations in the state of Florida. I don't know how many co-ops, let's say a few thousand more co-ops. How many of those are 3 stories and up? They actually don't know, but let's just say it's, a significant percentage, probably a majority, definitely a majority, I think. There's not enough time and not enough manpower to get all these buildings inspected in this amount of time, right? So, and that's just one category. Of those, I think the number I've heard is about 16,000 condos meet the age requirements to have milestone inspections done. I talked to one engineer a couple of weeks ago who told me, in her opinion, she doesn't think there's enough qualified professionals in the state of Florida, maybe not even in the country, to inspect this many properties in any sort of, quality manner in this amount of time. So if nothing else, there's not enough time to get all this stuff done. The qualifications we talked about, again, folks like us do reserve studies professionally. I'm a credentialed reserve specialist, which is an industry credential that's been around for a long time. A lot of reserve specialists come from architecture or engineering backgrounds. Some may be licensed, some are not, but this is really its own unique skill set. I mean, we're trained and have the experience and know how to look at a building inside and out, top to bottom, looking at everything from, the mechanical systems to the amenities, the parking lots, the pools and tennis courts. I mean, there's a lot that goes into a reserve study that you can really only know how to do that by doing it. Yes, it's helpful if you come from a particular educational background or some prior work experience, but there's a lot to learn in doing a reserve study. And I think, the engineers and the architects are excellent in their domain, and reserve specialists are great in our domain. And I think that those two really should be held separate. Do your structural evaluations when the time is right, when you need to, and then do your reserves and your capital planning, in conjunction with that. But, kind of conflating the two is not doing anybody any favors here. Let's see, Cindy, if we can go on to the next slide there. I put together a couple thoughts about just what properties should be doing now. What should you all out there do at this point? And I think Richard, gave you some good advice. Get in line for those structural evaluations, but maybe let's not panic and say that you need to get one done this fall. First of all, I think most of these engineering firms are pretty slammed as it is. Talked to another company last week that said, we're not even entertaining the idea of milestone inspections yet. We just have too much work to do as it is. So, I think, asking questions, maybe finding some good candidates for firms that you might want to work with, that's a good idea, but let's not jump to, clear this hurdle, which may change in the near future. And I wouldn't want any client out there to spend a bunch of money on something that they are not going to get the value of, or that they might have to do over for some reason. So in the meantime, I think doing what I would call a traditional reserve study, I think that's always a good idea. Especially if you've never had one done, or if it's been a while. Like I said, costs have changed in the industry quite a bit within the last couple of years. You really want to make sure that your data is accurate and that you're making good decisions using the latest and greatest details. A lot of things have changed. I mentioned elevators, any sort of major mechanical equipment, anything that's manufactured somewhere else, probably has been disrupted by supply chain issues. And we've seen costs for things go up, 30, 40% in some cases in a matter of 24 months. So that I would consider doing now, or updating your existing reserve study if you haven't. Now, the last point here is, I guess, more of a big picture idea. Now, there's one thing that we kind of touched on a little bit earlier in the call, which was this, waiving of reserves. Okay, up until now, condos have been allowed to waive reserve funding or to partially fund for decades. Now, Florida is unique in this way, as far as our company knows. And again, we work all over the country. We have 12 offices throughout the US. Florida is the only place where condo residents have been allowed to vote and weigh in on this waiving of reserve funding, which is never under any circumstance a good idea. Any dollar that you don't put into a reserve account at a certain point in time as a dollar you will have to make up for later on, either in the form of a higher contribution or a special assessment or a loan. There is no getting away from paying for roofs and painting and elevators and all the stuff we're talking about. So it's one of the, the great errors the state ever made was allowing the waiving of reserves in the first place. So that is a good thing that that's going away. I do think that that will stick. I don't think that's something that they will overturn when they issue new legislation here. Maybe they'll delay the compliance of that. Maybe they will allow a little bit more lead time for associations to fund their reserves. But I think the big picture is that residents out there, and you guys as board members, need to inform your residents that the cost of living is going to go up. Okay, you're going to have all of these inspections to pay for, the results of those inspections, and the funding of reserves that maybe wasn't a factor in your building before. Those are all things that are going to be a new normal, and I would highly encourage you to start taking that seriously as early as you can. So that's all I've got. I look forward to the Q&A, and I'll hand it back over to our host here. Thanks.
Well, thank you so much. I really appreciate it. And I think we should all walk away knowing that it's so important to do a reserve study. It's such a great tool, and it's something, if you're not doing them, you should really look into it. That said, I'd like to turn it over to Howard to introduce our next speaker. Thank you again.
Okay, can everybody see and hear me? Good morning, ladies and gentlemen. This is that time that you've all been patiently awaiting for, your favorite topic, insurance. Our next panelist is Joe Thompson. He's a partner with Gulf Shore Insurance. He's one of the brightest insurance minds, very, very active in condominium building coverage, has a number of the buildings that are participating today insured, as does the agency, Gulf Shore Insurance. I will just say this before I turn it over to Joe, that many of us have been reading about the changes in the law as it relates to insurance through the legislature. Most of that really affects our individual condo owners' policies. It doesn't affect the buildings that we're all part of. That's a part that's very much hurting, and Joe will cover that. So I would also like to ask Joe if he would cover what he's seeing from insurance carriers as far as inspections prior to the milestone dates in question. So without further ado, Joe Thompson.
Howard, thank you very much. GSAC, appreciate the opportunity to be part of this today, and panelists that have already spoken, you guys have done a great job. So appreciate the insights there. So obviously a lot going on with respect to insurance and condominium associations. The general special session that was put into effect by the governor was actually addressing two items. Obviously, the number of items that the legislature did not address during their regular session related to Champlain Towers South, which has been addressed in 4D that's been talked about. But there was also Senate Bill 2D as well, which really tried to address, it's incrementally addressing the litigation issue that we have in the state of Florida. When you look at the micro issues in the climate or the environment in Florida that are having a really huge impact on insurance right now. So 2D has kind of tried to slowly mitigate that. It built on last year's Senate Bill 76. So a lot of that is related to the statute 627-428, which is informally called the one-way attorney fee statute, where effectively insureds, or effectively the plaintiff, will get their attorney costs and fees awarded if the insurance carrier has to go through a trial and they have to issue a judgment or even a settlement after the lawsuit is filed. So that's been on the books in Florida for a long time. It goes back to Hurricane Andrew. There's a history there. But after Irma, we had a massive amount of claims, a massive amount of litigation, public adjusters, roofing companies involved, and it actually created sort of a little cottage industry in Florida with a group of, I would classify them as unscrupulous actors in those industries that have really driven that process to the extreme and has now created a situation where there's a litigation crisis here. And a statistic you've probably seen cited a number of times more recently, I think it was in 21, that Florida represented about 8% of all homeowners insurance claims in the country, which is not surprising given our population. However, we represent about 80% of all litigation related to homeowners insurance claims. So there's a massive disparity there. And the big issue with 2D was that the legislature is trying to modify the way that the litigation attorneys are compensated in that structure. Because for years, they were compensated under a methodology called a fee multiplier, a contingency fee multiplier, where the fees that they were awarded were arguably absorbent, much greater than your standard reasonable attorney fee that you would get with a carrier issued attorney through a D&O claim or through your association attorney. And again, back to that cottage industry, they really milked that and leveraged the system to the greatest extent possible. And now we're in a situation where insureds in Florida think that the proper thing to do with filing a claim is that to immediately sue the insurance carrier, go to a public adjuster, go through that process. It's very backwards. And again, I'm not trying to say, woe are the insurance companies. There's a lot of situations where insurance companies weren't paying, situations where insureds were upset with the potential settlement that they would get. And in that situation, I think everybody has a right to go down that path, but we shouldn't begin on that path. So the legislature is trying to change that a little bit incrementally. The other piece that they did was related to assignment of benefits. No longer can the assignees, meaning the public adjusters, roofers, et cetera, litigation attorneys involved, can they be awarded the fees? The fees have to be directly awarded to the insured, the named insured. So that these incremental changes will have a little impact. And again, typically things like this, it takes 18 to 24 months at a minimum for the insurance cycle to kind of take this into consideration. But the one thing that we all have to consider about this micro issue of litigation and how it's problematic for the insurance industry is that they have to model in Florida when they do these complicated modeling, property modeling for potential risks, what they call probable maximum loss. The insurance carriers have to now consider the issue of litigation and what's the probability of you as an insured, as a condominium association, suing me, not me, but the insurance carrier that we bring to you after the storm. So now they have to potentially look at that as an issue because they know it's a huge, massive item in Florida. And it becomes very difficult from a business standpoint because insurance, like every other industry, is a business. They're trying to make money, and it's difficult to do that in that environment. So what have we seen? We've seen a number of carriers exit the state of Florida. We've seen a number of insolvencies over the past year. It's actually been almost unprecedented until you go back to Hurricane Andrew, which is now the 30th anniversary, will be this month, of Hurricane Andrew. And we've seen a tremendous amount of underwriting discipline and just unprecedented underwriting changes going on in the industry. So all of this has had a material impact on condo associations. And these are just the micro issues that are impacting the state. This is before we even talk about all of the domestic weather events that have been going on since 2017. Think about all the named storms apart from Irma and Harvey, Laura, Sally, Michael, Ida, et cetera. All of those, you have wildfires happening in California, actually ones that are going on right now. You have unprecedented winter storm that happened in Texas. All of those events have a material impact on coastal condominium associations because the same carriers that underwrite all of those risks in other parts of the United States are also the same companies that underwrite risk here in Florida for condos. So when you look at that, the broader issue in conjunction with the micro issues going on in Florida that we're trying to kind of slowly mitigate, and through legislation, we're kind of getting there, but it's not quite remediated. It's a very difficult environment. And Howard had mentioned earlier, well, what's specifically going on, related to carrier requirements? Well, there's some things happening as well as a direct impact from the collapse of Champlain Towers South. So at first, when that tragedy occurred, I don't think anybody could have anticipated, what was going to happen, but we started to slowly see a massive impact in the casualty, umbrella, and the ex-wind markets for condo associations. So now, if you're a building that's over 40 years old, and this is completely aside from the requirements of 4D, if you're a building that's over 40 years old, we're now getting underwriting requests from liability markets saying, please send us an engineering report for that building. And they're not giving us any information on the format of the report. They're not asking what they're looking for. They just want to see that if there is a report, are there items that have been identified and have those items been fixed, repaired, remediated, et cetera, prior to the effective date? And if the answer is no, a lot of the preferred carriers that we would normally want to be partnering our insureds with will just decline the risk or just say it's not something that they have an appetite for. We've had a number of admitted markets that traditionally have always written general liability for condo associations are no longer doing that. Philadelphia was one of the first ones to backpedal. They said they're no longer doing buildings older than the year 2000. And we've had a number of other carriers as well that came in and did the same thing. So now we're faced with sort of a crisis there, because as we're being told that it's probably better that you wait until 23 to contact engineering firms for these reports for the requirements of 4D. On the other side of the coin, on the insurance side, if you're a much older tower, you're already being asked for that on the insurance front. So what's happening if you don't have it? So if you don't have it, unfortunately, we're in a situation where you're on a lower tier level of carrier, meaning you're with a company that will write that risk. However, we're seeing very unusual exclusions. For example, there's interior building collapse exclusions. We're seeing balcony injury exclusions. We're seeing water damage exclusions related to property damage or bodily injury. So there are companies that are willing to underwrite that risk if you don't have an engineering report, if you're a 40-year-old building or older. However, it's coming at a significantly increased cost with a lot of coverage carved out of the policy. So that should be a consideration as you kind of weigh all these other issues that you have to consider with 4D as it relates specifically to the insurance. And we're also seeing the Champlain Towers South tragedy have an impact on the umbrella industry as well. So the carrier that was actually underwriting a big piece of the umbrella for that tower, which was Fireman's Fund, they're completely divesting themselves of condominium association towers. They've pulled out completely. A lot of the boards or committees on the call probably have received a notice of cancellation from their umbrella carrier, Fireman's Fund. So that was a big blow to the different products that we access for umbrellas. A lot of these products are called risk purchasing groups, where there's a number of carriers that come in and they specifically create a program for the condo association industry. And these are very competitive products. There's about 5 before the Champlain Towers South collapse. Now we've had 2 that have completely disappeared. They no longer want to write that type of a risk. And we have others that are getting very detailed in their underwriting, so much so that they're not offering any options for buildings that are not fully sprinkled. So again, the older towers, they don't like anything that's a short-term rental. So they're getting very particular. And in the absence of being able to be in one of these risk purchasing group umbrella programs, where traditionally associations are used to 25, 50, 75, $100 million limits, which is very robust and necessary with that type of an exposure. If you can't find those programs, we now are faced with layering your umbrella coverage. And that comes at such an increased cost comparatively to where the umbrellas are. So not only on the property front are we experiencing massive hard market pressure because of the micro issues and the broader domestic issues that I mentioned, but now we're seeing major crunch and a pinch in the casualty market, the umbrella market, and the ex-wind market. So another carrier, Great American, which was one of the companies that was on the ex-wind component of Champlain Towers South, they paid out the policy limit. All the carriers did in that case, the umbrella, the general liability, the ex-wind property carrier. They also pulled out of Florida as well. They're no longer doing condominium. So that created another void that we didn't anticipate in the insurance market, in situations where with a lot of these towers where we might do a wind-only carrier and pair that with an ex-wind carrier. Great American was the premier, most competitive carrier for that type of an arrangement, but now they're no longer writing business. So it's become very difficult in this environment to deal with this. So it's something that I think every association should be considering in terms of, the effects that you're going to see on the renewal and what you should be anticipating. The pool of companies for various lines of coverage now are becoming smaller. And when you're dealing with a smaller pool of carriers, you're dealing with less competition, you're dealing with less favorable terms and conditions. So it's a very difficult time in the insurance industry. It was almost like a 1-2 punch with the hardening in the marketplace, the collapse of Champlain Towers South. It really just became the perfect storm of issues that have had a major impact on what we're seeing. So there's a lot to be said for that. And I think with that, I'll just kind of sum it off with that piece, because I know we're going to want to have time for Q&A.
Wonderful. Thank you so much.
Yep, I think Howard said somebody was muted.
Oh. Howard, you'll need to unmute yourself.
I was just thanking Joe for his presentation, Cindy, that's all.
You're welcome. Thank you.
Absolutely. David, would you like
Yes, thank
to
you.
take the floor?
I will. Thank you very much. And thanks to all 4 of you. You all did a terrific job in making your presentations. And I think most of the questions that we've been submitted have been answered, but I'm just going to tick through them again quickly to make sure we have. So question number 1 had to do with the language in the new law seems to require that reserve funding for the 10-year required SERS items be held under the straight line method, not the pooled or cash flow method. Steve, maybe, or Will, maybe either of you can answer that.
I can take a crack at that one first. Yeah. So I can read this either way. I think by one reading, they're saying we want that the funds for these 9 structural elements are protected and restricted and not available for use on other things like lobby remodeling or pool furniture or something like that. There's another way you can read it, which is that each of those 9 needs to be its own straight line reserve account. So a roof reserve would need to be established, which is separate and different from a windows reserve. And the money cannot move from one to the other without the vote of the owners, kind of in a traditional straight line approach. I'd be interested to hear a legal interpretation from Steve, but to me, it's either of those things. I think again, the spirit of what they're trying to do is they don't want money that was intended for something important and structural to be used for something that is, in the words of the bill sponsor, Danny Perez, cosmetic, right? And I think that's one of the flaws in this legislation is that the bill sponsors, not being experts really in this field, have a tendency to think of everything as structural, critical. If you don't do this, people are going to die, or it's fluff and it's unnecessary. And it's a total oversimplification of the situation. Yes, there are certain things like fire protection systems and the structural elements of a building that can lead to dangerous conditions. But again, from a financial standpoint, all of the things that are present in a condo building add to and contribute to property value. So yeah, the lobby is not as important as the elevators, but it still needs to be funded for. So those are things that would fall into kind of that other category, which they're really not imposing any restrictions on. They're saying, yes, you can pool your reserves for all these non-structural things. But I don't know, Steve, if you read that differently, do you have a strong sense if they mean to say 9 separate straight line categories and then a pool, or is it 2 pools that can't be mixed together?
Depends what my client wants the answer to be is my short answer. But no, I think that it can be interpreted different ways. There's no way I can give a clear answer to this because of the ambiguity. I did say previously in this in my presentation that I'll bet my salary that the Division of Florida Condominiums, if it's confronted with a case on this, would say that the money set aside for the load-bearing walls can only be used for the load-bearing walls. It's a consumer protection agency, and it tends to see things in a way, they will interpret statute in a way that they deem to be protective of the owners, to protect them from the mean, nasty dictators on the board of directors. So that is the mindset. And so I think that's how they would interpret it. But hopefully that's something that would be addressed in the next legislative session. Just picking up on some comments made before, I think the idea that associations should have reserves and that it would be best for them to be fully funded, or to require the percentage vote of the owners to be higher to, let's say, partially fund reserves. That to me is a more compelling issue and will do more to protect owners in buildings than to require reserving for items that would not have to be replaced barring a collapse of a building. So I think the point, we don't want to be insensitive to the tragedy that occurred, obviously, but I think to me, the point of these issues, the overall point of these issues is what can we do that will in fact make people safer in buildings? And to me, that's what the legislature's focus should be in the next legislative session.
Okay, good. Thank you. Next question. This was more of a statement, and it probably, Richard, you're probably the one who can answer this one. It says it's unclear how a licensed individual or firm preparing the report will be able to come up with estimated useful life, estimated remaining life, and estimated replacement costs for load-bearing walls, floors, foundations, and other open-ended structural items.
Exactly. So basically on an item like this, my recommendation to any association is first, I would go through and compile your history on the building. What projects have you performed in the past on the building? This would be any kind of capital improvement, any standard improvement, any maintenance project on the building. A lot of this documentation would show, okay, at this point in the service life of the building, we performed this work and it cost about this much money. The helpful use of these documents would be you'd be able to project, using your reserve study, okay, how much more life did we have out of this? What did we pay back then? Where are we at in the life cycle of our building from the date that the certificate of occupancy was issued? That would help the engineer and also the association determine, hey, what kind of things are we not looking at big picture here? Again, because those several items were very vague under the SIRS structural integrity study item that SB4-D listed. Again, us personally, we're waiting for that update from them. But, in the meantime, I tell whatever associations, reviewing this and trying to plan for the future, number one, they should sit down, try to compile any documents they have for the building, try to build up their history of what the previous boards or what, the developer or anybody has done on the building since the day it was built.
Okay, good, Richard. Thank you. Steve, this one's for you. Steve Falk provided a brief synopsis of SB4D. The legislation calls for pre-funding all items and disallowing waiving or partially funding reserves. Does this mean owners must immediately pay the total required reserve investments upfront for each 10-year period?
The answer to that is no. You would be required to fund reserves based upon the reserve study and in part based upon the structural integrity reserve study, if that remains in the statute. So what you do is you determine how much you need to have when you have to perform the deferred maintenance or replacement cost, and you build that up over time. Now, if the conclusion is that you must perform these structural repairs in the next year or the next 3 years, then that would determine how much funding you have to do. If the engineer, and mind you, my client, the statutes refer to architect or engineers, but my clients have always hired engineers to do these structural studies. If it says these structural items need to be replaced in 2 years, and you've got a major problem on your hand. You're talking about severe structural issues, and at that point, how much you have to fund in reserves would be a moot point. You'd have to do a massive special assessment and deal with an emergency situation, or borrow money from a bank and then pay it back with a special assessment. But the answer is no, it doesn't have to be funded in full up for the entire 10 years.
Okay, good. Next question. I'm not sure who will answer this one. Maybe Richard or but the question was, if we have a building with a garage that is linked to the building through a walkway, not underneath the building like many of the high rises are, and overhead covered, and has an overhead covered roof, maybe carport, would the carport of the garage also need to be included in the structure, in the structural study?
No, under what the current SB4 legislation lists, it lists that carport structure would be a separated element. So the way to determine this would be under your structural details. Hopefully you still have your plans for your building. You determine what is the connection. Is it a standalone structure because of an expansion joint, or is it physically tied into that structure? Again, this is what I call a gray area of that original law.
Okay.
I'll, if I can just add on to that, though, I mean, even though it may not be required in this legislation, if you have a roof on a structure, whether it's a carport or not, or even the, some of these aluminum or wood framed carport structures themselves may need total replacement at some point, that still is a reserve component. That's still an obligation of the association that you should be tracking and funding for and planning for, whether or not it falls under this specific requirement or not. So, we would routinely put something like that in a reserve study already.
Okay, next question. When deficiencies are found, will they need to be addressed under the code when originally built or the current code? Obviously, this will have a definite bearing on the amounts reserved.
So it depends on the amount of deterioration found. And again, Steve's original document regarding the roof requirement and what percentage of it dictates what would be a full tear off or a full repair. So again, depending on the amount of deterioration found, the building department, who's the authority having jurisdiction, would determine what's required in terms of what code you need to meet for this repair work. In majority for the state of Florida, they require your work to be performed to the current building code standard at the time of permit application, which at this time is the 2020 Florida Building Code 7th edition.
Okay, good, thanks. And the next question, does an assessment to cover the repairs to comply with the milestone report need approval by all of the homeowners? Steve, you probably would know the answer to that one.
Can you repeat your question? I'm sorry.
Does an assessment to cover the repairs to comply with the milestone report need approval by all of the condo owners, homeowners?
That would depend on your condominium or cooperative documents.
Okay, that's pretty straightforward. So if your documents require it, the answer is yes. If they don't, the answer is no.
If your documents require, you can have a legal debate as to whether that's enforceable, but if arguably that would be enforceable, but I mean, it would depend on the circumstances, really. How much of an emergency is it?
Okay, got it. So then there's one more question, and I'm not sure this is really totally relevant to the discussion, but I know there'll be an answer to it. Can the board of a condominium force owners at their own cost to replace windows and doors that are owned by the owners?
Ownership, the unit boundaries is a separate issue from who is obligated to maintain a particular item under the documents. That's for ordinary maintenance, repair, and replacement. If we're talking about repair after a casualty, the windows would be part of the association's responsibility, both to insure and replace after a casualty.
So if it's just to replace the windows because they're getting older, could the association mandate that it be done?
That would depend on the, in other words, if it's an owner maintenance obligation, then the question would be, can you mandate someone that an owner replace a window, even though it's not in bad condition, it's just not up to the current code? And I'm not sure an association can do that.
Okay.
I'd like to add something to that. I think this is a good quick point, even though it's not as relevant to 4D, but in terms of building component and building envelope integrity, the exterior openings are a critical component of that, and to how associations are modeled and how they fare from a rate standpoint, and also in terms of how eligible you'll be for future capacity in the marketplace. The carriers are going to be looking for the fully mitigated building. So I have a few clients going through this discussion now where they're experiencing a lot of water intrusion, not even with named storms, just standard thunderstorms that happen. And they have a lot of owner holdouts that don't want to change out original windows or just older windows, but yet maybe 80% of the building has been retrofitted with impact glass. So I think there needs to be a discussion on that. And I know obviously you'd have to consult with Steve or your association counsel on how you would move forward in that regard as an association. But it is critically important if you can frame the discussion from the standpoint that this is having a material negative impact on the building envelope by these owners not replacing their windows. I personally, I mean, again, my opinion is that you can make the argument for enforcing a retrofit in that case if it becomes a common issue that's deteriorating the building or impacting everybody negatively from a financial standpoint. And owners will see a benefit as well when they get upgraded glass too on their HO6 policy. But again, I don't want to get too far off topic, but when Steve was talking, it just kind of spurred my thought.
Okay, good answer. So I know, Steve, you answered this question, but just to make sure, in case the person who posed it still online, the question was whether the legislation, the SB 4D, also applies to HOAs.
The answer to that is no.
Okay. And then last but not least, since this is so new to us, the one question is posed, what can we do to be sure that the engineer we hire has our best interest in mind, has the proper experience to do our study and inspection? And are there enough of them with experience in Florida to help us?
So the best commentary I have on that is you should be reaching out to a structural engineer who's licensed in the state of Florida as a structural engineer. And that engineer should also have experience with building envelope experience. You know, they should know what they're doing with maintaining a building. They should know how to understand architectural details at minimum, because those are items that actually affect structural elements of the building, is a lot of times dating back to original architectural design.
Okay, good, thanks. So that wraps up all the questions we received either online as part of this Zoom or in advance. So I think I'd like to wrap it up. And again, I want to say thanks to Richard, Will, Steve, and Joe for the great, terrific job today. We really appreciate your time and willing to participate in this. And also, again, I want to thank Daryl and Howard and Jeanne for getting this all set up, and for Cindy getting it all pulled together technologically. Other than being short of access for a few people, I think it went exceedingly well, and hope you all agree. I'd also like to point out that this was recorded, as you know, and in the next few days will be uploaded. So for any of you, if you want to pass this on to additional people to look at, I think that would be great. And I've also had a couple of suggestions that we'll probably want to do this again in another 3 or 4 months when we see what shakes out with a lot of that stuff. And I think that's really a terrific idea. So unless any of our other board members, Jeanne or Daryl or Howard or Cindy have anything else to say, again, I want to thank everybody for participating. Hope you got a lot out of it. I certainly did. And we'll talk to you all soon.
Absolutely. And as you're departing, please remember to sign up for our newsletter, because we'll be sending the video out through our newsletter list. So if you're not already receiving our newsletter, sign up at gsacnaples.org. Thank you and have a lovely day.
Thank you.
Thank you, everyone.
Thanks so
Thank
much.
you.